Hi, this is Jay with Personal Bar Prep, and this is Simplified, our video series designed to simplify complicated subjects on the California bar. Today, we're going to simplify parole evidence. So, first let's talk about what parole evidence is, then let's go over the elements of parole evidence, and then I'll give you some examples on how it's used. First of all, parole evidence is actually an evidentiary issue regarding the admissibility of prior or contemporaneous negotiations with respect to the meaning of a contract. So really, this is a very limited application. It applies to contracts in the context of whether or not you're allowed to use prior negotiations in order to explain the contents of a contract. So let's go through what the elements are. First of all, it requires that there be a fully integrated contract. The rule is that where you have a fully integrated contract, you may not offer any kind of prior negotiations or contemporaneous negotiations other than contemporaneous writings in order to modify or change or add to or amend or contradict the fully integrated contract. So let's talk about what those things mean. First of all, what does it mean to be a fully integrated contract? A fully integrated contract means that it is the final expression of the party's intent. It's everything that the parties meant to put in that contract. And where you have a fully integrated contract, you may not use anything to modify it, to alter it, or to contradict it. The written contract is what stands. So the first question we then have to answer is, how do we know if we have a fully integrated contract? And there are a couple of theories that you learned in law school that really have evolved into one theory. And the theory is, first of all, read the contract. Read the four corners of the document and see whether there's anything missing from that document, or is this what you would expect to find in a document of this nature? Okay, that's the first rule, the first analysis. If everything is there, it appears to be a fully integrated contract. And if it's a fully integrated contract, you can't use any prior negotiations to contradict it or to add to it, etc. Now, there's another step to that, however, because oftentimes you'll find that even though a contract's language is clear and everything is in it, the parties are not conducting themselves according to the terms of the contract. They're doing something different. And so as the rule has evolved, we know that a contract is fully integrated not only by the language, but whether the parties are conducting themselves according to the terms of the contract. And if they are not conducting themselves according to the terms of the contract, and that contract is interpretable by the party who wants to get the parole evidence in, then the contract is not fully integrated. And if it's not fully integrated, that means it's not the final expression of the party's intent, and as a result, you're allowed to use parole evidence in order to modify it or contradict it. Now we have one more angle here, and that is a partially integrated contract. That's a contract where everything that's in the contract belongs there, that's what the parties intend, but there's something missing. And this is the kind of thing you're going to more likely see under the UCC, because under the UCC, there are only a couple of terms that are necessary for a valid contract. You don't even need a price term. So if a price term is missing, it's obviously not a fully integrated contract, and then you can use UCC gap fillers to fill in the price, but it doesn't destroy the contract. And so what we end up with is a partially integrated contract. The rule for a partially integrated contract is you are allowed to use prior negotiations, meaning oral testimony of what was said while you were negotiating, any written evidence of what was said prior to contracting. You're allowed to use all of that when you have a partially integrated contract to clarify a missing term. But you cannot use it to contradict anything in the existing contract, because everything that's there is supposed to be there. The thing that's missing may be supplemented, like a price. And you use various UCC gap fillers to do that. For example, how the parties have conducted themselves throughout this arrangement, what the parties' past dealings have been, what the plain meaning of the language is, etc. So there's a host of ways to fill in what's missing. So let's look at some examples and see how this works. Not too long ago, there was a bar exam question in California where the contract required that when a company received notification that another company's waste disposal vessel was 80% full, that the party who received the information had the obligation to empty that waste container vessel within the next 48 hours. Now here we are up against a holiday weekend in this fact pattern. It's 4:30 or 4:40 on a Friday afternoon prior to Memorial Day. And the waste disposal company gets a phone call from the lab that produces the waste and says, you got to pick it up within the next 48 hours. And the waste disposal company says, no, we don't, because we discussed during negotiations that we never pick up on holiday weekends. And we also know that in 3.5 years of this 5-year contract, every time a holiday weekend has been involved, they've been excused from picking it up. So now the question is the holiday weekend part of the contract or not? The plaintiff, the one who wants it picked up, they're going to say it's a fully integrated contract. It says everything we want it to say. It's a long contract. It had a lot of provisions. It had everything you would expect to be there. But on the other hand, the waste company is going to say, we're not conducting ourselves like the contract says, because every holiday weekend, we're able to pick it up after 48 hours. And since the evidence shows that that is a reasonable interpretation, we conclude from that it is not a fully integrated contract. And so we're allowed to now look at the prior negotiations, and we see that when they discussed the timing of this, they had concluded that holiday weekends would not be included in the 48 hours. And so there is an example of a contract that looks to have everything in it, but it doesn't. We don't know anything from the terms of the contract about holiday weekends. So what you end up with is a contract that is not fully integrated. And as a result, parole evidence can come in. An example where it can't. A homeowner is purchasing, let's say, concrete in order to put a bed down to put a hot tub on top of. And the company they buy the concrete from sells it in either a 10-yard truck of concrete or a 5-yard truck filled with concrete. We don't know how much the buyer is going to need, so they purchase a truck full, and then the seller doesn't deliver. Well, when the buyer sues, the seller says, look, I have 2 different trucks. I have one that carries 5 yards, another that carries 10 yards. We can't possibly know which of those trucks I was supposed to be supplying, and so as a result, we can't possibly have a valid contract. And here's the problem. It's a fully integrated contract. Why? Because it says everything you would expect the parties to say, including quantity. It says a truckload. So how do we resolve not knowing what a truckload is? Well, if the truckload means something in that industry, then you're allowed to look at custom and usage in the industry to determine what that language means. We're not contradicting the contract. We're not adding to the contract. We're merely explaining a term of art. That does not violate the parole evidence rule, and that's perfectly fine to do. So remember, parole evidence rule is an issue regarding the admissibility of evidence concerning the negotiations of a contract. If it's fully integrated, you're not getting those prior negotiations in. If it's not fully integrated, you are getting them in. And if it's partially integrated, you can only get those prior negotiations in to clear up a misunderstanding of what's written in the contract. Now, through all of this, there's one other thing we need to know, and that is exceptions to the parole evidence rule. And the exceptions are very straightforward. If you can demonstrate fraud in the formation of the contract, or you can demonstrate there's a condition precedent to formation of the contract, or if you can demonstrate that there's an ambiguity in the contract, we don't know what it means, then the parole evidence rule will not be a bar to getting in prior negotiations. And the reason is pretty obvious, because when you have any of those problems, where you have an ambiguity, where you have a condition precedent to formation, or where there's been fraud to induce someone to enter the contract, you obviously do not have a final expression of the party's intent, because they probably haven't agreed on anything. That's the parole evidence rule. If you like this video, you're going to love our class. Do me a favor and like this video or leave a comment. Thank you very much.